Very nice that everybody's here. I want to welcome some people in particular, Philip's partner Rose, his parents James and Amy, his sister Katie, and his brother Joseph, and everybody who's there, his friends, student, fellow students, collaborators, and everybody else making this a great day. Uh, in E-IPER, Philip has two co-advisors from different fields necessarily. And I'm in earth sciences, and Buzz Thompson is a lawyer in the law school. And so we're his main co-advisors, but he's had a lot of interaction with the rest of his committee. Philip is a quintessential E-IPER student. His work has spanned natural science and social science by incorporating law, economics, water resources, environmental preservation, and he's made fundamental and applied contributions. So backing up a bit, how did Philip get here? He was Phi Beta Kappa coming from the University of North Carolina in environmental sciences. He then went to a position of a research associate at the Environmental Law Center in Washington, D.C. for about 2 years. I'm doing innovative conservation planning for an endangered species mitigation. And then finally, he applied to Stanford, and he applied to the law program to get his JD and to the E-IPER program, and he got into both programs. So he received his JD in 2016 and was admitted to the Colorado bar, so he is a lawyer. And then Philip went on to study a bunch of things and do a bunch of things in addition to his doctoral work, and I'll mention just a few. Interestingly, he worked with Buzz Thompson on a US Supreme Court case where it was a water rights, water appropriations doctrine case that was involved with involving a dispute between Montana and Wyoming. He worked at the Nature Conservancy to develop a conservation planning framework for environmental water transactions in Colorado. He then went to work at a law firm as a summer clerk in Denver. And one thing that he did, which was not part of his dissertation, was he used his training and his as a lawyer and in water resources, and noticed that there was an important legal decision that was made at the federal level that had ramifications for water rights to indigenous communities. And he put together a team, and the team ended up publishing with Philip's leadership a paper in Science in 2018. So in addition to his science paper, he's published 6 other papers, 2 of which you're going to hear about today. And on top of all that, he's received a lot of recognition for his work. The first thing is he got a Stanford Interdisciplinary Graduate Fellowship, which is something awarded to students who cut across traditional disciplinary boundaries. He received a Switzer Foundation Fellowship for leadership capacity and commitment to environmental problem solving. And then he got a Babbitt Center Dissertation Fellowship, which is awarded to research contributing to integration of land and water policy in the Western US. Now, Philip is one of the hardest working people I've ever met or I've ever seen. It's been a delight to work with him. I can go on and on talking about him, and I'll leave the time to him. But he's destined for greatness, I think. He deserves to be head of an influential organization like the EPA or becoming a federal judge. And that's my view. And in closing, I'd like to say that when I have students who work in my group, and Philip's been sitting in my group in hydrology in the School of Earth Sciences for some time, I like to present the students with a memento of what their time is here. And so Philip now has a package, and Philip, you can feel free to open this package, which was mailed to you with do not open instructions on it. A lot of suspense here.
Yeah, I know. I don't think I've ever opened a present over the internet before. A gavel.
You got to read the inscription.
I'll show it to everyone. Philip Womble, JD PhD, here comes the judge.
Okay. All right, without further ado, it's a great pleasure to give you Philip Womble. Philip, it's all yours.
Thanks so much, Steve, for the kind introduction and for that gift. That was unexpected and really nice. And thanks everyone for joining. I'm really excited to share my work with you today on water rights markets in the 21st century. Let's go ahead and start. Today's talk will consist of 5 different sections. First, I will provide motivation for my work. Second, I will outline my research questions. Third, I will run through some background definitions to make sure that we are all on the same page. Fourth, I'll show some results from my work. And then finally, I'll summarize contributions from the work. In the Western United States, access to water is controlled by legal claims to that water. And by 2030, 61% of watersheds in the Western US are projected to have no remaining legally unclaimed water. This means that in those locations, water will be locked away from growing cities, new industries, farms, and ecosystems, unless that water can be reallocated away from those existing uses effectively. Also, in many of these locations, full allocation or over-allocation of water occurred without setting aside any water for the environment. This means that there's no water for fish, no water for plants that grow alongside the river, no water for other important parts of riverine ecosystems. And as a result, major rivers run dry or virtually dry during substantial portions of the year across the West. Markets for water rights present one promising mechanism in the Western United States for adapting water use over time and for reallocating water use. However, water markets are not free markets. Instead, they are complex institutions that are constrained by complicated interwoven sets of property rights laws, market conditions that often depart from economic ideals and ecosystem needs, as well as hydrology and infrastructure. And when I was just looking at this triangle, creating the presentation, it struck me that this really summarizes why I went to law school, why I did a PhD with focus in hydrology, and why I ended up conducting economic research, was so I could understand these interwoven sets of trade-offs that, that govern water rights markets. During today's talk, I will address 2 questions. The first question is, how can we create more adaptive and efficient water rights markets? This question draws on both law and economics. And then finally, the second question I'll ask is, how can we more effectively restore water for ecosystems using water rights markets? That question will draw on all 3 fields listed on your screen. Now, I've already mentioned water rights a couple of times. Some of you are probably wondering what those actually are. In the Western United States, the prevailing system for allocating water allocates water on a first-come, first-served basis. Formally, this system is known as prior appropriation, and it allocates water to older, more senior water rights before newer junior water rights receive any water. Now that we know what a water right is, what is a water rights market? To understand, let's examine the most common type of water transaction in Colorado, where a municipal buyer or a city buys water from a farm. So in this transaction, the city would buy the farm's water right. Water rights are property rights like land. And importantly, for the water rights place, type, or timing of use to be changed from the farm to the city, state legal approval is required. This is the essence of a formal water transfer, which we'll spend a lot of time talking about today. And there are actually 2 flavors of formal water transfer. These transfers can either be permanent or they can be temporary leases. Now, why did I decide to study water rights markets in the state of Colorado? One of the longest running data sets of water marketing in the Western United States found that in Colorado, a majority of water transactions in the Western United States had occurred. That Colorado had the most permanent transactions of any state in the West. And that more recently, 1 of every $7 spent in the environmental water market in the Western United States was spent in the state of Colorado. Colorado also has some of the most developed water law in the Western United States. So way back in 1882, Colorado became the first state to rule that prior appropriation was the only legal doctrine for allocating water. And 14 of the 17 Western states then effectively have followed Colorado's lead. As a result, about a third of the nation's water attorneys are actually members of the Colorado Bar, and Steve already told you that that includes me. So let's dig into Colorado a little bit more. Let's learn about the geography of the state. Like many arid regions, Colorado experiences a geographic mismatch between where precipitation falls and where people live and farms are located. So about 70 to 80% of precipitation in Colorado falls west of the Continental Divide. That would be the blue regions shown on the map here, while about 80 to 90% of the state's population lives in the eastern half of the state, and that side of the state also has about half of the state's irrigated acres. Colorado administratively manages water on the basis of water divisions. So these 7 different regions shown on your map are each water divisions. And for purposes of today's talk, you can also think of those divisions like water marketing regions. One very important division is the Grade N region shown in northeastern Colorado. This region is the most active water market region in the state. It has by far the most people. So Denver's located there. By far, it has the most irrigated acres in the state and relatively scarce water supplies. So let's dive into our first question. This question will look at legal barriers to trade in water markets, as well as non-ideal market conditions, so that we can first understand barriers to more adaptive and efficient water markets. And then after we understand those barriers, we will examine some potential solutions. And the method that I used to do this analysis was a survey, which I'll talk about in a few minutes. The agricultural to city water transfer that I outlined earlier was actually not hypothetical. This scenario was based loosely on a real water transfer that occurred on the South Platte River in northeastern Colorado. And that particular transaction, after submitting their application to receive legal approval to transfer the water right, 45 parties actually legally objected to the transfer. That resulted in a 16-day court trial and an appeal all the way to the Colorado State Supreme Court. As you can imagine, hiring lawyers and hydrologic experts to face off against 45 objecting parties is not cheap and can be a substantial barrier to trade. So when I think about water markets, I find it helpful to take a step back and first think about ideally what would water market policy look like. And there are 2 important components of ideal water market policy. First, such a policy would balance the economic benefits provided by individual water transactions against the cost of those transactions to other water users in society in the form of third-party effects or negative externalities. And second, ideal water market policy would clearly define property rights. However, Western United States water law does not do either of these things. First, it implements a no injury rule that strictly prohibits any change in the time, place, and amount of water available to other water rights. And that applies now or far into the future. It's been reported that in Colorado, legal battles have occurred over this no injury rule, over volumes of water less than a cup of water, 30 years in the future. Second, Western US water law implements a use it or lose it policy that limits transferable water to actual historical water use instead of the flow rate or the volume of water that might be on the paper water right involved. When I started law school at Stanford, I knew that I wanted to model environmental water marketing, and I started reading legal literature and talking with water market practitioners. And in that process, I learned just how costly and expensive it can be to secure legal approval for water transfers of any kind. And it quickly became apparent to me, based on these conversations and based on what I was learning from the literature, that transaction costs, so litigation costs in this case, were a primary, if not dominant factor driving real water marketing. And so I was surprised to find, when I started reading more of the scientific literature and economic literature, that essentially all water market models omitted these transaction costs, and that the few that did include them did so on the basis of theory and very limited empirical data. And I also found that even though there was this lengthy discussion of transaction costs in the literature, no predictive statistical models of those costs had been developed in a Western US water market. And so with that in mind, I moved to Colorado for 5 months. I hired 2 graduate students at the University of Colorado, and I recruited 100 Colorado water professionals that actively work on water transfers. These were water attorneys and hydrologic experts to participate in a survey. The objective of the survey was to measure the litigation costs. So these are the costs both for lawyers and for hydrologic experts to complete water transfers. In this survey, we were looking just at costs for permanent water transfers. We looked at those costs for the proponent of a water transfer, not objecting parties. And we looked at transfers that had any kind of end use. So not just an end use of a city like we talked about earlier. So during the survey, I drove all over the state of Colorado along with my research assistants. We had wide-ranging hour-long discussions with these professionals about water marketing. And during those interviews, we collected both quantitative and qualitative data. But the core of the interview consisted of survey questions about transaction costs. The reason that quantitative research about transaction costs has been relatively sparse is that the data on transaction costs are generally not publicly available. They're often poorly recorded, or they're just sensitive. So sometimes this cost data is protected by attorney-client privilege. With that in mind, we had to elicit these costs using hypothetical but realistic water transfer scenarios. You can see one such scenario on your screen here. We did this once in person, and then we actually did it 5 more times in an online survey afterwards to give us hundreds of sets of estimates. The scenarios started off with just 3 attributes. So we specified the seniority or priority of the water right being transferred, the location of the transfer, and the volume of water being transferred. Some of you might not be familiar with an acre foot of water. That volume is a foot of water put on an acre of land. My objective with the survey was to quantify expected transaction costs. So the expected cost before a water transfer began, we needed 2 sets of data. So we asked 2 primary questions. The first question asked, what is the probability of different legal outcomes given the information in the water transfer scenario? And the different legal outcomes range from very low conflict legal outcome of ruling by the water referee, who's like an assistant judge, all the way up to a very high conflict outcome, which would be an appeal to the Colorado Supreme Court. Second, we revealed the legal outcome for the water transfer, and then we asked for low and high estimates of transaction costs for transfer that had that outcome. So now let's dive into some results regarding barriers to existing barriers to adaptive and efficient markets. We'll mostly explore results for senior water rights because those are more often traded. Based on answers that we received to the first survey question, I developed a statistical model of the probabilities of different legal outcomes for water transfers. So on the y-axis, we have probability. On the x-axis, we have volume of water transferred. Here you can see that the predicted probabilities for 2 of the lowest conflict legal outcomes. These are both before the water referee, who's sort of like an assistant judge in these cases, that they both decrease as a function of volume, meaning that those lower conflict outcomes become less probable for larger transfers. For most volumes, the most probable outcome is a settlement before the water judge. And higher conflict outcomes like a court trial or an appeal all the way to the state Supreme Court become more probable for larger water transfers. Now we'll move on to results from the second survey question that evaluated costs. Because uncertainty in transaction costs can also be a barrier to trade in and of itself, one of my objectives was to quantify that uncertainty. So here you can see 95% confidence intervals for a state Supreme Court appeal, and for a very large water transfer of 40,000 acre feet, the total transaction cost spans from $775,000 all the way up to about $1.5 million. For now, we'll focus on transfers that are 1,000 acre-feet or less because those are by far the most common. As anticipated, here we can see that greater legal conflict generates higher transaction costs. That was expected, but the magnitude of these costs has not been quantified before, and so that's useful information for decision makers. Also, quantifying the costs with these different levels of legal conflict was essential for the next step in our analysis. So I mentioned earlier that our objective was to estimate the expected value of transaction costs before a water transfer occurs. And why do we care about expected costs? The reason we do is because buyers will consider those expected transaction costs before they decide whether or not to enter into a water transfer. So when we join together our estimates of the probabilities of different legal outcomes for water transfers with the total transaction costs given different legal outcomes, we estimate the expected transaction costs shown here. These are the black dotted line. We also explored uncertainty in those expected transaction costs, and we can see for a 1,000 acre-foot transfer that they range from around 300,000 acre-feet or $300,000 all the way up to $450,000. An important characteristic of transaction costs is that they exhibit substantial scale economies with lower unit costs for larger volumes of water transferred. Also, we found that senior water rights transfers had higher transaction costs, expected transaction costs, than junior water rights transfers. This is because senior water rights transfers have greater potential to cause third-party impacts to other water users. We not only explored transaction costs in the most active market region in Colorado, this is that region with Denver, but we explored them across the state of Colorado, including in regions that have a lot of water and not so many people. And what we found is that in regions with greater water scarcity, transaction costs tend to be higher, and in regions with lower water scarcity, transaction costs tend to be lower. I mentioned that during our in-person survey interviews, we also collected qualitative interview data. When we analyzed that data, one of the most important findings we encountered was that water market transaction costs have increased over time, and that the most commonly cited reason for that was growing water scarcity. And going back to where we started today, these findings are important not only within the context of Colorado, but also given anticipated increases in water scarcity across many parts of the Western United States. So now that we understand barriers to more adaptive and efficient markets, let's explore some potential solutions. To do that, we're going to ask the question, how do specific legal changes to water law, how do those impact transaction costs as well as third-party impacts? We explored two general categories of legal change, the first being modifying the no injury rule, and the second clarifying the definition of property rights. There are actually four specific legal changes that fit into these two categories. The first is a flow threshold before injury would be considered. So I mentioned earlier that there, for example, have been some lawsuits arguing over a volume of water equal to a cup, and so those would be prohibited because they would fall below this flow threshold. Second, because it can be difficult for proponents of water transfers to prove that no real or hypothetical injury will occur to other water users both now and in the future. This legal change would shift the initial burden of proving injury from the proponent of the water transfer to the objecting parties. Third, instead of having the proponent and the objecting parties in a water transfer each develop their own quantification of transferable water and then fight over it, this legal change would develop a standardized quantification of transferable water. And finally, the fourth legal change would abolish the use it or lose it policy for certain water transfers. So let's explore the impacts of those various legal changes. We see that the flow threshold provides some of the greatest percentage reductions in transaction cost at low volumes traded, but those reductions dissipate for larger volume transfers. This is likely because larger transfers would be less likely to escape scrutiny below that flow threshold. Second, we see that shifting this legal burden of proof for the issue of injury from a proponent to the objecting parties provides moderate reductions in transaction costs. We see that the third legal change actually provided two different sets of projected changes in transaction costs. We found that lawyers thought that this legal change would provide fairly substantial reductions in transaction costs, while hydrologists did not. And then finally, at most volumes transferred, abolishing use it or lose it provided the greatest percentage reductions. Now, lowering transaction costs that to enable economically beneficial water transactions, that's just one side of the ledger in our ideal water market policy, and third-party effects must also be considered. In particular, the injury to other water rights that is currently legally prohibited must be considered. And so to evaluate this, we played a card game with our survey participants. We gave each participant 4 cards, 1 card for each of the legal changes that I outlined earlier. And we asked the survey participants to rank those cards from the legal change most likely to increase injury to the legal change least likely to increase injury. When we evaluate the results of that game, we find that the legal changes that would modify the no injury rule have a significantly greater probability of being ranked most likely to increase injury than legal changes that would clarify property rights. In conclusion, in part 1, we found that water market transaction costs show systematic heterogeneity, that water scarcity drives transaction costs both over space and time, that expected transaction costs are substantially uncertain, and that legal changes that clarify the definition of property rights join together some of the greatest reductions in transaction costs with relatively low negative externalities. So let's proceed to the second question. How can we more effectively restore water for ecosystems using water rights markets? To do this, we'll layer in some additional economic considerations. We'll explore thin water markets with relatively few buyers and sellers, and we'll also consider ecological water needs. And I will do this using a computational model. For the modelers in the audience, this will be a simulation optimization model. In the second part of the talk, we'll shift our focus from the state of Colorado to the Colorado River Basin. The Colorado River has been described as the most overallocated river in the world. It supplies about 40 million people with water, 5.5 million irrigated acres, and in fact, it is so overallocated that the river has only reached its natural outflow in the Gulf of California once since the year 1998. One major shortcoming of Western US water law is that it initially reserved no water for ecosystems. Environmental water rights markets offer a solution to this problem by buying or leasing consumptive water rights and then protecting them for those ecosystems. The basic idea is to go from a low flow condition to a high flow condition by trading water. One way to understand the ecological benefits from environmental water transactions is flow alteration ecological response relationships. And so in this second section's analysis, I evaluate ecological benefits from environmental water transactions using such a curve for adult rainbow and brown trout that was developed in the Colorado Rocky Mountains region. Trout form an important component of Colorado's $2 billion recreational fishing economy. They are used as an indicator species by the United States government, and many existing environmental water rights list trout habitat restoration as one of their objectives. Importantly, trout habitat also exists across our model study area, and so we can evaluate basin-wide impacts of environmental water marketing. In the first part of today's talk, we focus solely on formal water transactions that receive state legal approval. However, one important development within environmental water markets in the Colorado River Basin in recent years has been informal leasing. So a recent Stanford study found that in recent years, from 2014 to 2018, an overwhelming majority of environmental water transactions were actually of the informal variety. They were these informal leases. And in the state of Colorado, at least, this represents a dramatic shift because virtually all environmental water transactions before the year 2014 were of the formal kind. So we already talked about formal water transactions at the beginning of the talk, but what is an informal lease? Perhaps the most important distinction between a formal water transaction and an informal environmental water transaction is that formal transactions provide legal protection for restored stream flows, while informal environmental water transactions do not. What does that mean in practice? To understand, let's all pretend that we work for a conservation group, and that group wants to evaluate participating in an informal transaction versus a formal transaction, buying water from the same source. So the source of water for this transaction is going to be the farm that's green on your screen and is upstream. And the brown farm is a farm downstream that has insufficient water at the moment. You can also see that there are 2 river reaches that have insufficient water supply for fish. So if we participate in a formal water transaction, legal protection for restored stream flows keeps that second downstream farm from taking the increased stream flows to irrigate their farm. It protects both of the downstream river reaches, or restores flows in both of those locations. But if we participate in an informal lease, the downstream farm can simply take the increased stream flows and use them to irrigate, because there's no legal protection for restored stream flows. Additional distinctions between formal and informal transactions are that formal transactions bear greater transaction costs, while informal leases do not. Formal leases have to satisfy the trading rules we talked about earlier, while informal leases do not. In Colorado, at least, formal leases are more geographically limited in their availability than informal leases. And formal leases have 2 different types of transaction source. So they could be a diversion structure, or formal leases have occurred in Colorado from reservoirs, while informal leases have only occurred from diversion structures. So in essence, informal leases have been an adaptation to barriers to trade, like those we talked about earlier. In addition, there's been no systematic study of the ecological cost effectiveness of informal versus formal water leasing. So we'll now focus on the Colorado River within the state of Colorado. The purple outlined region provides about 31% of the mean annual flow of the entire Colorado River. Although substantial sums of money have been spent on environmental water transactions across the Western United States, something like 418 million between 2008 and 2018, to date, environmental water marketing has been largely opportunistic. And so stated differently, environmental water markets have struggled to shift from local projects to regional or basin-wide strategies. My work intends to overcome this struggle by developing a basin-scale computational tool for strategically investing in environmental water transactions. The objective of the tool is to maximize ecological benefits provided by portfolios of environmental water market transactions with a fixed financial budget. The tool or the model evaluates leases, temporary leases, instead of permanent transactions like we discussed earlier, because they have been the dominant transaction type in the Western United States. The tool evaluates 2 different categories of sources that could sell water for the environment. So leases from diversion structures and reservoirs. These leases are performed on a monthly basis. And because low flow conditions generally exist during the summer, during the irrigation season, and because nearly all environmental water transactions in the state of Colorado have occurred between the months of May and October, we evaluate monthly leases and during those particular months. The model joins together an optimization algorithm with a highly detailed water rights simulation model of the study area, and the simulation integrates various economic, legal, hydrologic, and ecological components. So I mentioned earlier that I was surprised to learn that transaction costs had been omitted from prior water market models. I was also surprised to learn that other important legal and economic factors had been omitted from these water market models. So water market simulations have generally assumed that water markets follow economic ideals. In addition to assuming zero transaction costs, they also commonly assume active markets with many buyers and sellers, that those buyers and sellers have perfect information, that the commodities being traded in the market are homogeneous, that the market reaches an equilibrium price or equilibrium prices. These are just a few standard assumptions in past work. There's a large empirical literature, however, showing that these assumptions are frequently wrong in many water markets. So in addition to having large transaction costs, water markets are generally thin with few buyers and sellers. Those market participants have imperfect and asymmetric information. They're buying and selling heterogeneous commodities. Price dispersion is a phenomenon that has been observed frequently in water markets where there are different prices for the same commodity. And in addition, even though, as we've already seen today, water markets and water rights are intricately linked, water market models like mine have generally not simulated the process of administering water rights by priority. And so my model addresses some of these deficiencies, and I'll highlight those in green text in the following slides. Unlike past models, instead of assuming that all water users participate in the market, I developed a statistical model that identifies users that are more likely to participate based on past environmental water transactions, and then select 20% of users for evaluation. That's the percentage who said in a recent survey that they would participate in leasing. I used the transaction cost data that was developed earlier as an input to this model. And in addition, where water market prices are unknown, I developed a statistical model to predict those prices, and the prices vary for different types of seller, region, source type, and different transaction types. However, where we know prices, there are various sources of water in the study area that actually publicly advertise prices. We just use those known prices. I'm aware of no existing water market model that compares formal and informal leasing. The trading rules that we talked about earlier, to my knowledge, have been omitted from every water market model to date. And although priority-based administration has been considered in some past water market models, that consideration has typically been relatively limited. So, for example, in one of the more advanced recent studies that did this, the water market model evaluated 12 water users with 20 different water rights, and my model evaluates as many as over 4,000 monthly leases of over 2,000 different water rights from as many as 526 different water users, although the results that I'll show today are limited to leases from just 170 water users. Instead of assuming that market participants have perfect information, I developed a statistical stream flow forecast that predicts summer flows based on snowpack and other climate data that's available on April 1st. Because leasing begins in May, that allows 1 month for government approval of formal leases. And then finally, to examine ecological benefits of environmental water transactions, I used the flow ecology relationship that we discussed earlier. So more specifically, the objective of this modeling framework is to maximize trout habitat with the state's current budget for environmental water marketing. So let's examine some results. We talked earlier about how informal leasing has been an adaptation to barriers to trade in water markets, but we don't really know whether this shift has been good for the environment. And so we'll examine that question here by first examining how informal transactions change water provided by optimal environmental water market portfolios. And then second, we'll look at the habitat impacts of considering informal transactions. To answer this question, we'll look at two separate analyses from the model. The first will show an optimal portfolio that only considers formal leases, and then the second will consider all leases. First, I'll show results showing the amount of water acquired by each portfolio, and then I'll show habitat impacts. And we'll examine these in a dry year. In the formal leasing portfolio, even though 170 different sources of leases were considered, only 2 were ultimately selected, 2 large reservoir leases. The reason for this is that leases from storage reservoirs offer certain economic and ecological advantages. First, leases from storage reservoirs can achieve scale economies in transaction costs. The lower reservoir shown on the map also has one account that is enrolled in leasing in this portfolio that has extremely cheap water. So this might not mean anything to some of you, but the water is only sold for $7 an acre foot, which is a just incredibly low price. That's one of the publicly known prices we considered. Ecologically, leases from storage reservoirs allow for water to be released when fish need it. So they provide temporal advantages in that fashion. And the optimal market portfolio with only formal leases provides almost 21,000 acre feet of water. So let's take a look now at the portfolio that it considers informal leasing as well. Well, we see that the two reservoirs that were selected in the prior analysis are considered again, are selected again here. But in addition, there are numerous informal diversion leases. The total volume of water acquired by this second portfolio is almost 60,000 acre feet. So there's almost a 3 times change in the volume of water acquired. So we see that here there's substantially more water leased for the environment when informal leases are considered, but does that actually improve habitat? So let's take a look at that. Here we see that with only informal leases, there are fairly moderate habitat gains downstream of one of the reservoir leases. So between a 5 and 10% trout habitat gain there. There are also more modest gains on many other river reaches around the basin. Meanwhile, when informal leases are considered, we see that even though those leases do not provide legal protections for restored stream flows, in some cases we see double-digit percentage gains in trout habitat. So as gains as high as 17%. And those higher gains in trout habitat are shown in locations with Navy river reaches. When the trout habitat benefits are averaged over all of the river miles in the basin, we see that portfolios that include informal leases provide 1.5 times the trout habitat gain of portfolios without them. So let's take a closer look at 2 of the river reaches that see some of the greatest gains with informal leasing. The dark blue values, again, and as well as the light blue values, these are the change in habitat. They're not the absolute habitat value. And so if we take a closer look at these river reaches that had substantial habitat gains, in both of the locations with those substantial gains, we see that before any leasing occurred, they previously had very low habitat, so less than 10% of maximum. So as one example, almost all of Divide Creek shown here, which is on about 20 kilometers long, has poor habitat. And this isn't hypothetical. Just 2 years ago, Divide Creek actually ran dry. After we implement the optimal portfolio with informal leasing, we see that those stream and river reaches are no longer in that very low habitat status. In conclusion, in part 2, we learned that formal reservoir leases offer ecological and economic advantages. And we saw that in a dry year at least, considering informal water transactions increases the water acquired by 3x and the habitat gain by about 1.5 times what it was without those informal transactions. In sum, today we explored 2 questions about water markets at the intersection of law, the environment, and economics. We found that clarifying property rights present a promising avenue for legal reform in water markets, that informal environmental water leasing represents an ecologically positive development. And finally, water law in the Western United States was developed all the way back in the 19th century, and the origins of the two legal trading rules that we discussed earlier, the no injury rule and the use it or lose it policy, those can actually be traced to specific judicial court decisions in the 1850s and 1860s. Our results here show how those legal decisions in the 1800s continue to constrain water use and water marketing today. And with that, I will take your questions. Thank you.
We have an anonymous question for you, Philip. So what does it mean when when you say dry versus little water? When does it become important, and can models account for this?
So the flow ecology relationships that we use to evaluate ecological benefits of environmental water transactions are somewhat general relationships. And so they explicitly state that they should not be used to predict trout biomass. And so what we're doing here is exploring trout hydraulic habitat as a result of these transactions. There are other studies with different types of flow ecology curves that find that there may be, minimum thresholds below which restoring water doesn't really have any measurable impact on trout habitat or trout populations. But the threshold that I explored in those final sets of maps, the 10% threshold, has been used in some other flow ecology curves to distinguish between when to essentially to draw the line between when the improvements in flow would have no measurable benefit to trout populations and when they would start to have those improvements. And so that's why I used that threshold in the final set of maps.
Okay, another question. Have you been able to present your work to nonprofits working to protect trout habitat in Colorado? And do you think they might use your model in practice going forward?
Yeah, so that was one of my objectives in developing this. The model was to develop a tool that conservation groups could potentially use to direct spending in environmental water marketing. As I think Steve highlighted at the beginning of the talk today, I actually worked a summer for the Nature Conservancy in Colorado. They're one of the more active organizations participating in environmental water marketing in the state. And I've maintained regular discussions with them, as well as with the Colorado Water Trust, which is another leading organization involved in environmental water marketing in the state. And they're definitely interested in using the results of this work in some form or fashion to inform their spending decisions. They, for various reasons, will probably not use it to select specific portfolios of water rights, but they are definitely open and excited about the possibility of internally using the model to consider which leases they will enroll in. And I guess just to give a more specific example, the Water Trust every year runs a request for water program that is sort of like an RFP process where they try to elicit various bids to participate in environmental leasing from water rights holders across the state of Colorado. And so a model like mine could be used internally at an organization like that to decide whether or not to or to evaluate the various bids that they receive.
So we have another anonymous question. When you consider the effect of importing water on your models, do you also take into account the effect of removing that water from another region?
The answer is yes. So the Upper Colorado River Basin simulation model that we use includes an incredible amount of detail on these types of import and export operations that you're discussing. So trans-mountain exports are particularly important in the study area where my model was developed. That river basin actually supplies almost 500,000 acre feet to eastern Colorado, again, because there's more water in western Colorado than the east, but there's more demand in the eastern part of the state. And the operational rules that govern those trans-mountain exports they're integral to all of the simulations. So all of that is factored in.
Could this model be applied to other river basins, and what are the opportunities to use this model to improve river management? It sort of follows on the last one.
Yeah. So the first question, could it be applied in other basins? Could be applied relatively easy in other basins in Western Colorado. The simulation model that we use substantially builds off of the state of Colorado's existing water allocation model for the Upper Colorado River Basin, and other similar models exist for other basins in Western Colorado. And so we could take our framework and actually lift it and apply it in some of those other basins, because the Upper Colorado is actually one of the more complicated operational basins in that region. Moving the model to other parts of Western Colorado wouldn't be so difficult. However, moving it outside of the state of Colorado would be technically pretty difficult. One advantage of working in Colorado on research like this is that Colorado has some of the best available data and models on water rights, and that data is often not as available in other states, and so it would require gathering a bunch of information on diversions and actual diversions, water rights, and then building a model from the ground up in those other states to do an analysis like this.
So the next question is, do you have an opinion, even though it's not in the scope of your study, about which legal reforms that you propose are most likely to gain political, actually be actualized politically, or have faced the most obstacles politically?
Yeah, so the fourth legal change that we explored, the one that offered the greatest transaction cost reductions, this was abolishing the use it or lose it policy for certain water transfers. That was actually implemented shortly before we ran our survey, but there had been relatively little experience. None of the folks we talked to had actually used the law. And so in terms of political possibility for implementing that change, it's already happened. In terms of the other changes, I would expect that, and this is in line with our results, suggesting that legal changes that clarify property rights may be a little, they may be more tenable because they're less likely to increase injury to other water users. The third legal change that would develop a standardized quantification of transferable water, I think would be more, I mean, just based on, sort of what I read, would be, it's my opinion that would be more politically possible. And the reason for that is that back in 2017, the state of Colorado, they ran a study bill where they didn't actually implement this legal change, but the Department of Water Resources there, the Division of Water Resources, studied it. And so that legal change has been explored more with practitioners than the other remaining two.
Okay. Well, another questioner has a vote for you to become the head of the EPA, but in the meantime wants to know whether you could use a framework like this for other kinds of problems like air quality.
Yeah, that's a great question, and I think it could apply in other types of environmental markets. In fact, conservation planning models like what we developed for the Upper Colorado River Basin have been implemented to some extent in other environmental markets. So one example would be wetland mitigation markets under the Clean Water Act. This is another type of aquatic resource market where developers have to buy offsets for paving wetlands or impacting streams. And a big point of emphasis for the federal government over the last 10 or so years as part of that program has been to promote watershed planning approaches that pick the best conservation sites, but and there's a third-party market there that provides and sells mitigation offset credits. And so a conservation planning tool like what I developed in the second part of the talk could be useful there. In terms of the first part of the talk, our analysis of how we can create more effective and a more adaptive and efficient water markets actually, and sort of in a broad sense, draws a lot of insights from other environmental markets. So in other environmental markets like carbon and to a somewhat lesser extent, air quality, there are more fungible standardized commodities with low transaction costs. And so the specific legal changes that we explored, they attempt to work within the confines of water rights law in the Western United States, but to achieve those outcomes that have been seen in other environmental markets.
Okay, Philip, last question. We need to finish up here so that people can get to your reception at 5. So the question here is the differences that you found between lawyers and hydrologists. How do you explain that? Yeah. And what would happen if you put economists into the mix?
I don't know the answer to the latter one because we didn't speak with economists, but the reason that probably the most likely reason why hydrologists and lawyers had different opinions about the third legal change, this is the standardized tool for quantifying transferable water, is that prior to our survey, the state engineer's office in Colorado, so this is the administrative office that oversees water rights administration and other water rights issues in the state, they had taken some steps in the direction of developing standardized tools. Like there were specific employees that worked at the state engineer's office who had suggested that a certain irrigation efficiency tool should be presumptively correct in at least part of the state, and that had received a lot of backlash from the community of hydrologic experts that we spoke with, and so for that reason, that's I think the most likely reason why we see a difference between lawyers and hydrologists. I mean, I guess the other reason is just hydrologists have more intimate experience with calculating transferable water. That's usually their work during a water transfer, and lawyers are, they talk to them about it, but are not actively involved.
Okay. So unfortunately, we have to stop the question period, and now is your time, Philip, to do your acknowledgements.
Great. So work like this is not possible without a lot of support from a lot of different organizations. It's such a privilege to be able to come to a school like Stanford and do research on whatever topic you want. And I'm really grateful for the funding sources and the other sources of support that I've received along the way to do that. In terms of funding, I am especially thankful for the funding support I've received from E-IPER, from the Stanford Earth Program, from the Lincoln Institute, and from the Switzer Foundation. Another Stanford resource that has just been incredibly essential to my work has been the Sherlock Supercomputing Cluster. The Stanford Research Computing Center's staff have helped me immensely more times than I can remember. I mean, I've just walked in there completely confused about certain modeling issues, and they have helped me figure them out. Also, the modeling work that I did just would not have been possible without the computing resources that they provided. And I'm also really grateful to have received computing support from Microsoft's AI for Earth program. At various times we were running simulations on like 100 or more different computers. And so again, just incredibly grateful for support from those sources. And before I thank my committee, I would like to thank two people in Water in the West who are not formally on my committee, but who have served like committee members or mentors for me during my time at Stanford. First, I'm really thankful to have been a member of Nusha Ajami's research group. My first few years at Stanford, I didn't have a research group I could go to that was focused on policy relevant quantitative research on water in the Western United States. And I was just so fortunate to fall into working with, to going to that group. Nusha welcomed me into the group like one of her own students. She spent, she spent a lot of time like reading papers that I've written. And at any rate, I'm very thankful for Nusha's support along the way. I'm also really thankful to have worked with Leon Sheptitsky, who's now at University of Virginia, but formerly was executive director of Water in the West. Leon's door was always open to me. Whenever I, had to talk through various water rights issues, he'd always be happy to chat. He provided a lot of insights about valuable research directions that I should pursue. And I think, probably half the time that we were talking, we actually talked about college basketball, and I certainly appreciated that. I'm really thankful also for the Gorelick Hydro group. In the E-IPER program, we spend a lot of time talking about how sort of weird it is to show up your first day of graduate school and be expected to strike out your own research agenda. And I felt that way. And then I joined Steve's group and I realized that it actually wasn't that weird, because all of us in Steve's group were grappling with doing complicated interdisciplinary research and constructing our own agenda. I mentioned that I was a member of the Ajami group, and am also thankful for feedback I received from folks in that group. I was fortunate enough to have 2 different E-IPER cohorts, and am really thankful for the social and intellectual camaraderie that I gained from both of those cohorts. The E-IPER staff has been just essential. I've been at Stanford for a number of years, and everyone from E-IPER has just really supported me. And in particular, Anne-Marie and Gabby have been really supportive and helpful these last few months leading up to the defense. I'm thankful for my time in the environmental law clinic in the law school. Joe Tom Wood was really supportive. He is a Colorado water rights engineer who happened to live in Menlo Park, and just gave me a lot of insights about water transfers in the state of Colorado based on his decades of work experience there. Thankful for my survey research assistants. They were really great. And just thankful for my friends during graduate school. I've been reminded in the last few weeks, sometimes, those of you that know me probably know that I can be a little bit cynical sometimes. And in the last few weeks, as I've been going through practice talks, I've just received some really positive feedback from various friends about my work. And so I'm just thankful for folks that have been sort of relentlessly positive along the way. Moving on to my committee, I'll start with Steve. So I think the first thing that has to be said about Steve as an advisor is Steve is more available to his students than I think any professor that I have ever heard of. Steve spent a ton of time working on this presentation with me. He, I think if I emailed Steve at like 2 a.m. on a Saturday, I would expect to get a response in 10 or 15 minutes. That's just how available and helpful he is with his students. In addition to that, I can still remember, when I first was looking at graduate schools back in 2011 or 2012 and first met Steve, I was a little confused why a world-renowned expert in, hydrogeophysics and hydrogeology, water systems optimization, was interested in working with a prospective law student who had relatively limited quantitative research experience. And I came to learn after a few years that Steve actually has some legal bona fides as well. Steve was actually involved in some arbitration litigation years back, and they went to the 10th Circuit. And there's a law review article written about the Gorelick rule. So I think, sort of joking aside, this is a way that, I just wanted to say thanks to Steve for indulging my long discussions of law. At times, lawyers and scientists think sort of differently about the world and how research is done. And I'm also thankful that you took the time to teach me to think like a scientist. Buzz, I feel like there have been a number of times when I've come into your office with my head deep in a modeling problem, and you've taken the time to step back and remind me that you're actively involved in about 20 or 30 different environmental, typically water issues across the Western United States that are just incredibly interesting. I've always enjoyed those conversations, and I'm particularly thankful that I got to work on the Montana v. Wyoming lawsuit early on in my time in law school. When I tell people that the first real water litigation that I worked on was a Supreme Court interstate dispute, that I just think that's really fortunate and kind of crazy. Third, Michael, I'm really thankful that I ran across Michael after about 3 or 4 years at Stanford. I knew early on that I was going to want to work with a water economist given the nature of my work, but I had trouble finding an advisor who both understood, an economics advisor who both understood water rights and was expert in stated preference techniques. And I'm just really fortunate I ran across Michael for deploying our survey in Colorado. One thing that I remember with Michael is when we were working on writing the papers that we published from the first part of today's talk, I would send them to Michael, and then he would come back with these edits that were, you know, it made it very clear that he had read almost every source that was in the bibliography for the papers. It allowed him to really come along with me on the intellectual journey of learning about Colorado water law and to contribute meaningful insights to our work there. I've enjoyed meeting with David Freiberg over the years, really enjoyed taking your classes. They were, the information that I learned in those classes was really helpful for model development and my research. I'm also thankful that when I would meet with David, he would often remind me to try to figure out what I enjoyed most about the work I was doing, which sometimes I forgot to do. And also that he always asked me, or often would ask me, what practitioners thought of the work I was doing, since that was really my original motivation for doing this work. And then finally, Bruce, thanks so much for taking a few hours out of your day today. I know that that is a major commitment, and I was really excited to have you as my chair, just given your background in Western US issues and knowledge of water in particular. I'd like to thank my family for supporting me along the way. You know, there are a number of times I've called home and talked to them about the work that I was doing, and they were nice enough to sort of smile and nod, and I think at the end usually say, that sounds complicated, but you should keep doing it. They really supported me along the way, and just very thankful for that. In addition to my immediate family, also, I wanted to thank my partner Rose's family, her brother Max and her parents Mike and Natalie, for their support along the way, and for being very supportive of their daughter being with a professional student for many years. And then finally, I'd like to thank Rose. It's hard, I don't really know where to start with this one. I guess I'll, you know, maybe the place to start is with our puppy that's shown here, who's not so small anymore. But we talk a lot as grad students about how difficult a PhD can be, and it's really hard, but I think sometimes we don't talk enough about how hard and how much sacrifice it involves for partners of people doing a PhD. Rose has really sacrificed a lot over the years to support me finishing my work, particularly in the last few years, and she's taken care of a lot of just practical aspects of my life that I would have otherwise neglected. And Rose has also, you know, been an intellectual partner. She's read papers I've written, provided really nice feedback there. And importantly, Rose has also always, you know, reminded me to have fun and to take time away from work. So with that, I'll wrap up.